strategy is the referendum strategy, which I understand we're going to hear about, right? And then the last one, which is really the most urgent, because that has to happen right now, and that's the civil action to require the government to not implement the law on July 1st. I've just become a part of a new organization called the Montana Cannabis Industry Association, and we've raised quite a bit of money in the last 24 hours, and we're about halfway there in order to hire arguably the top constitutional civil litigator in Montana, Jim Getz. But what's key in all this is that we need that lawsuit to be the first to the courts. It's got to be the first to the courts, because if we have a whole bunch of lawsuits, and I know everyone wants to sue, I know probably half of you already all sort of lawyered up and you're ready to go sue and say, this law is terrible, don't do it. I'm leaving that to Jim Getz. He's got ideas about it. In the larger jurisdictions, then there's usually 4 judges or so, and you don't know for sure which one you're going to get, but you have a chance to boot one. But like in Missoula, they're all terrible, which is kind of surprising. I mean, hey, come on, Missoula, right? But in Missoula, I'm told that none of them are going to be very useful to us or helpful to us. But there's other jurisdictions where if we have a plaintiff there, and it's a one-judge town, and it's a great judge that we think will understand the issues, then that's probably where he'll choose to file. So what we need immediately is money and perfect plaintiffs. And by perfect plaintiffs, I mean business owners, patients, people who work in auxiliary businesses, employees of businesses who have never had a freaking parking ticket, who didn't smoke pot before I-148 came out, who are just upstanding members of society, who are participating in the industry either as a patient or a caregiver or some peripheral something or other, and are squeaky clean. And so if you've got ideas, I'm all ears of who that might be. Email me at john@montana. The media is our friend and foe. And I've pledged with Jason to try to stay out of the media, and so if you are sort of cornered by media and you feel like you need to say something, then say that SB423 ruins medical marijuana, and look into the camera and say, please, Governor, veto this bill. That's what I'd say. Yeah. Yeah. So that's all I've got.
Next up we have Mr. Gallus, and he's going to talk about the law. He's a lawyer from Helena, and he's actively involved in with the people that are writing this bill. So kind of sort of he'll explain a little bit more about himself.
Thanks. It's a pleasure to be here. As Jason said, I am an attorney from Helena, Montana. I practice in the field of elections and ballot issues, campaign finance, things of that nature, wherever I can. And like all Montana attorneys, I think we do a little, or have to do a little general practice. People ask me kind of what I do, and you usually look at that, or when I explain to them, at least with political stuff, ballot issues and campaign finance, they look at that and tell me that it's a unique area of practice, which means that I must be an idiot and I'm probably starving to death. But I enjoy what I do. I have not been involved in your issue. I did not advocate for or against the bill when it was there. I, like everyone who lobbied the legislature, saw many of you there, or many in the industry, and watched it progress that way. So I'm not an expert in what it says. I understand that it is extremely detrimental to you, and to such an extent that one of the options that you're considering is to repeal the law, which is an option provided you by the Montana Constitution. And in talking to Jason, he asked if I could come over and talk a little bit about that and tell you what the process is, what a couple of things I think that you might face, and some things that might be important to you. I have written ballot issues. I have defended them or assisted in their defense. I have challenged them as well. Both, and I've taken them in writing them. I typically take them through the process that you will start with. Now getting that to the Secretary of State, Legislative Services Division, and then on to the Attorney General. Sometimes that's all I do, and then other times I'll stay on and a lot of times stay on and help with campaign finance and reporting. So that's kind of my area of expertise and what I'm limited to today. But if you, I'll go through the process, and if you have any questions of me, please feel free to ask them. I do better in a question and answer kind of a thing anyway. I know Jason wanted to limit those a little bit, and I'll just leave it up to him or you guys as to when we should cut that off. To begin, and just kind of to go off your sheets a little, but not entirely. The Montana Constitution does provide in Article 3, Section 5, for those of you that are interested in the sites, that Montanans can challenge an act of the legislature, and they do so in what's called an initiative referendum. You can get 5% of the signatures, the qualified electors in Montana, and get something that the legislature has enacted onto the ballot for a vote of the people on whether or not that should be approved or rejected. If you, as has been done on one occasion, get 15% in 51 legislative house districts, you can suspend the act at the point that you hit that mark, that you're certified to the governor, and that is, I think the correct figure for that is 73,011 verified signatures in total. And then you also need to qualify, when we talk, the Ninth Circuit had rules in that. So those are kind of the animals you're used to seeing, and by comparison, that's what you're probably talking about doing in a short time. So when the legislature adjourns, what happens then is you have 6 months to go through the process that I'll talk about quickly, and gather the signatures, and then turn those into the county election administrators for certification by the Secretary of State. Now, you need to be to the county election administrators 4 weeks before the actual deadline for the certification. So right off the bat, you're talking, you really got 5 months. And there is some question, but I've not seen a clear rule of law, but rather an interpretation that IR 114, I believe, the energy dereg, at least according to the legislative services, was premature because it had not yet been acted upon by the governor. The Constitution doesn't say that. My quick review of the statute did not say that. And unless somebody were to tell me, otherwise, where that was kind of a written in stone rule, I would say that the legislature has acted, that the legislature has adjourned, and that it would be right to, put that in upon adjournment of the legislature, rather than waiting the additional time period for the governor to decide whether to sign, veto, or let this become law without his signature. So, and again, they may have a different point of view on that, but I didn't see anything definitive in my quick review.
So really, in order to prevent the repeal, which happens July 1st, and turning everything over, we have 4 weeks, because we have to get it done in 4 weeks, so that we have the 4 weeks prior to it accomplishing it.
Right. Here's the process, and here's how it works. You need to draft the title, which you can do now. That used to be only drafted by the Attorney General, but proponents can do that now. You're limited to 100 words, so all of those rules that are in the statute apply. And then you write the for and against statements, and there are rules with regard to how that works as well. The 25 words you're limited to, but you need to word things in such a way that I think that passes time. It's something about it passes every time, but it's that generally they like it to be, the for statement indicates a positive and the against indicates a negative. So they try to get you to write them that way. If there's a fiscal impact, that note also needs to be drafted, but you won't do that. The Attorney General will order that if he suspects that there is a fiscal note that's needed for the measure. There was a fiscal note with the bill, so I would assume there was. But so you draft the text of the proposal ordinarily, but that's drafted for you. So you need the enrolled copy of the bill. And you submit that along with the statements to Legislative Services for their review. They have 14 days from the day that you start with the Secretary of State, but then they'll deliver it to the Legislative Services Division that day. And then the Legislative Services Division has 14 days to review that. They don't need to take all 14 days, and with something that's like a bill that they've already reviewed for constitutional things and this and that, there's not likely to be a problem. The one area of restriction is whether or not there's an opinion that it meets the legal requirements for submission to the voters. One of those is whether or not there's an appropriation that's contained in the bill. That was also an issue, I believe, in IR 117, and it was decided in the sponsor's favor that even though there were money or unfunded programs, basically, that was not an appropriation. It was a grant of authority as such, but it didn't result in an appropriation. Imagine that would be the case here. The other kind of, I guess, slam dunk win for that would be if it was removed because somebody thought it was an appropriation of money. That would, since this started in the Senate, and legislative rules say that it could not, if that were the determination, you'd win right there. Don't get your hopes up, but it just isn't going to happen. I'm saying that more along the lines to suspect that there'll be a ruling that this is not an appropriation. Typically, the other things that you worry about are single subjects, whether or not you're handled more than one subject with an initiative